Chapter 2, Civil Procedure, or How to Get Things Done. Many people picture the law as something far more complex than it really is. This is largely because it's translated by people in robes who speak Latin that you're required to stand for and refer to as Your Honor. Put that way, it sounds a lot like the clergy who, at one point in time, gave their sermons in Latin, which only they understood. Despite this sort of highly intellectual mirage cast over the law, it really isn't quite as complex to understand as you might initially think. And lawyers are not your intellectual superiors as some might hold themselves out as. I have found that despite being literally told I was in the country's intellectual elite while in law school, lawyers are not really all that more intelligent than the average educated person, and they're subject to many of the same flaws in logical thought as the next person, despite their training and education. The best way to think of lawyers is as though they're mechanics. I sometimes jokingly refer to us as lawsmiths, as though we operate within the law the way a woodsmith, silversmith, blacksmith, or gunsmith would work with their various mediums. We're experts in law, but only due to training and experience, not due to any inherent superiority over the general population. The purpose of this next chapter is to walk you through the entire process from start to finish, from the moment you first decide you want to sue someone in civil court, all the way through a trial, and then a series of appeals, should you choose to do so. I will also talk about some of the ways you might go about solving your civil dispute outside of court. To do this, you'll need to understand not only the natural flow of a court case, but also the way in which the court system is constructed. Lastly, and this is vitally important, understand that what I'm talking about here is a very broad overview of the legal process. Also, this is for the civil process. While there is some overlap, the criminal system will have some differences that we will cover in the chapter on criminal law. The following will not cover every single situation and nuance of a court case, and what is covered is being covered very broadly. In other words, the information will set you on the right track and give you a good roadmap of what is happening in a case, but you will absolutely want to consult an attorney who specializes in the field of law you are currently dealing with. Pretty much everything you will read in this book will have exceptions and exceptions to the exceptions. As I said before, I am not giving you a bird's eye view of the law, but rather the view from orbit. Court types and classifications. The first question you're going to want to ask yourself is whether the legal issue you're dealing with is in the trial courts or the appellate courts. If your case is just getting started, it will begin in trial court. If the case has already gone to trial and is set for appeal, then you'll be in the appellate courts. The next question you need to ask yourself is whether your case is in state court or federal court. There are both trial courts and appellate courts in the state and federal systems, and it can be in any combination. We'll go into each of these below. Trial courts. If your case is just getting started, 99.9% of the time it will begin in a trial court. Trial courts are called trial courts because, well, that's where they have trials. Trial courts are what are called courts of original jurisdiction. Original jurisdiction simply means that the court is where the case will start. A trial court consists of an arbiter of law and a finder of fact. The judge will be the arbiter of law. The judge interprets and applies statutes, administrative regulations, rules of evidence and procedure, and other forms of law applicable to the case at hand. The finder of fact is who determines if something did or did not happen. In some cases, this will be a jury. However, there are some trials where the judge will serve as both the arbiter of law and the finder of fact. This is referred to as a bench trial. It is called a bench trial because the judge is deciding all the facets of the case from the platform from which she sits, called the bench. Lawyers pass the bar exam because the bar is the little fence in the courtroom separating the lawyers from the spectators in the courtroom. The bench is where the judge sits. One way you'll see this at trial is when the attorneys are making objections regarding if evidence should be admitted. In this case, admitted means presented to the jury for their consideration. The judge reviews the relevant rules of evidence and, as a matter of law, decides if the objection is sustained or overruled. We'll talk about this later. The jury, being presented with the admissible evidence, will then be the decider of fact as to whether or not the allegations are true. Appellate courts. Appellate courts are those courts that review the decisions of prior courts. These decisions become the previously mentioned case law. As opposed to original jurisdiction, these courts have appellate jurisdiction. Some states flip the names, but most states have two appellate courts. The first is the State Court of Appeals. This court reviews the decisions of trial courts. The second is the state Supreme Court. This court sometimes reviews trial court decisions, but most of the time reviews decisions made by the state court of appeals. The general flow of court cases at the state level goes a little like this. You can find it on page 31 of the book. Starts with the state trial court, then goes to the state court of appeals, then goes to the state Supreme Court, then to the Supreme Court of the United States. The general flow of court cases at the federal level, in most circumstances, goes the district court, the circuit court, and then the Supreme Court. The district court is the name of the federal trial court, and the circuit court is the federal court of appeals. Note that in both the state and federal systems, the Supreme Court of the United States is the final arbiter on matters and makes case law that is binding for the entire country. When a case is sent to an appellate court, that court is reviewing findings of law. Overwhelmingly, they defer to the finder of fact unless there is evidence of misconduct or an extreme error. The court consists of several judges, called justices. The number of justices depend on that specific court. For example, the Washington Court of Appeals consists of a panel of 3 justices, and the Washington Supreme Court consists of 9 justices. The federal circuit courts have different numbers of justices, and the Supreme Court has 9 justices. When a case is sent to the Court of Appeals, the 2 parties send multiple extensive memos, called briefs, full of case law as part of their argument as to why the court should rule in their favor. After the briefs have been filed, their attorneys will make oral argument in front of the justices, answering their questions. The justices will confer on the matter and release their written opinion, answering the legal question before them, and in turn create more case law. The names of the party in the briefs can sometimes be confusing. Whereas in the trial court, you have a plaintiff and a defendant, in the appellate courts, you will have a petitioner or appellant and a responder or appellee. What makes this confusing to some people is that the names may change throughout the life of the case. The appellant is the person who lost at the previous court level and is bringing forth the appeal. The respondent is the person who won at the previous court and must respond to the appeal made by the appellant. Here's one possible example. Plaintiff Reed wins at trial. The defendant, Erica, appeals. At the State Court of Appeals, Erica is the appellant and Reed is the appellee. At the Court of Appeals, Erica, who is now the appellant, wins. Reed, who is the appellee, appeals to the State Supreme Court. Now, Reed is called the appellant in the State Supreme Court because he lost in the Court of Appeals and is bringing forth the appeal. Erica is now the appellee because she won at the Court of Appeals. At the State Supreme Court, Erica wins again, and Reed appeals to the Supreme Court of the United States. So once again, Reed is the appellant and Erica the appellee. Remember, the appellant is the person who lost and is appealing. The appellee is the person who won and must defend the win by responding to the appeal. I have a chart of this on page 34. State courts and federal courts. We've talked about the differences between trial courts and appellate courts. Both state courts and federal courts have trial courts and appellate courts. What separates these courts is what jurisdiction they cover. In a state court, if a case were appealed to the Washington State Supreme Court, then the case law that comes out of that case is only binding to the courts and citizens of Washington State. You could cite to this case outside of the state, say in Idaho, but the Idaho judges are not bound by the rulings of the Washington court. You would only cite to case law made from another state in order to try to convince that state's courts that your idea is a good one, not that the court is bound by that law. The federal system is similar. In the federal system, you also have trial courts with original jurisdiction. These are referred to as district courts. Every state has at least one district court. Some states have more. Idaho has only one district court that covers the entire state. Washington has 2, a district court for the Eastern District and a district court for the Western District. California has 4. The federal system also has courts of appeal with appellate jurisdiction. These are called circuit courts. There are 13 of these courts. They hear appeals from the district courts. Rather than just covering a single state, the way state courts of appeals do, the geographical areas of circuit courts cover multiple states. For example, the Ninth Circuit Court of Appeals covers most western states. Idaho, Washington, Nevada, Montana, California, Oregon, Alaska, Arizona, and Hawaii. It also covers some of smaller territories such as Guam and the Northern Mariana Islands. Case law between the two types of courts is different as well. A state appellate court is only going to cover that state. However, if a court begins in a district court in Washington and is appealed to the Ninth Circuit Court of Appeals, all states within the Ninth Circuit's purview are subject to that case law. The Supreme Court. The last court is the Supreme Court of the United States. This is traditionally a court of appellate jurisdiction. In most instances, a case is appealed to the Supreme Court after either a state Supreme Court or federal circuit court has reviewed it. There are some very narrow circumstances where the Supreme Court may exercise original jurisdiction, such as when states sue each other. This is outlined in Article 3, Section 2 of the Constitution. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. There is nothing in the Constitution that dictates the size of the Supreme Court. It currently stands at 9 justices, but has had fewer in the past. Occasionally, people suggest adding justices. This often occurs when one party in power of the legislative and executive branch finds their agenda stymied by a judicial branch that is issuing opinions they do not agree with. Judges are all appointed in different ways, depending on the court and jurisdiction, but Supreme Court justices are nominated by the President. Their nomination must be approved by the Senate before they are sworn into their jobs. Supreme Court justices serve for life. The logic behind this is that we want justices to release their opinions based on their earnest understanding of the law. If they have to worry about being reelected or reappointed, then they might be motivated by a desire to keep their jobs, and therefore release only popular opinions instead of ones based on the law itself. While court rules vary, most of the time you have the right to appeal decisions you do not agree with, and those appellate courts at both the state and federal level will agree to review it. The Supreme Court does not work like this. This is simply a matter of logistics. The Supreme Court only has 9 justices. It's impossible for them to review the thousands of court cases that are appealed every year, so they must be selective in which ones they review. For a case to be seen by the Supreme Court, you will file a petition of certiorari. The petition will outline the legal issues of the case and why it's important for the court to review it. Most cases reviewed by the Supreme Court have a serious constitutional issue and/or there is a split across the country in how previous courts have ruled. Because the case law that comes from the Supreme Court is binding on every court in the country, the cases they see often settle national controversies. If 30 states have ruled one way on an issue but 20 ruled the other way, or if several federal circuit courts have conflicting opinions, then the Supreme Court's opinion will resolve the issue and make sure everyone in the nation is operating under the same set of rules. The Supreme Court, or more likely their clerks, will review the many petitions for certiorari and provide summaries to the court. If 4 of the 9 justices, note this is not a majority, wish to review the case, they will issue a writ of certiorari and the case will come up for appeal. How does the court interpret law? Whether you're talking about a judge in a trial court or the panel of justices in a court of appeals, one of the primary duties of the judicial branch is to review issues of law. They interpret and clarify ambiguities in the law, and they exercise the power of judicial review. Judicial review includes the power to strike down laws passed by the executive and legislative branches if they do not line up with the Constitution or laws from higher courts. The court has several tools and methods of understanding the law. The 3 primary ones we're going to discuss are the plain meaning rule, legislative intent, and public policy. It is important to note that the court only has the power to utilize these tools if there is no binding case law from higher-ranking courts. The plain meaning rule is the first tool a court should use to determine the meaning of a law. The plain meaning rule is exactly what it sounds like. The judge reads the words of the law and applies the clear and obvious meaning of that language. For example, battery is the unlawful and non-consensual touching of another. If a person pokes another in the chest, and the question before the court is whether this qualifies as touching, then the judge will hold that it is. A finger poke might not cause injury, but under the plain meaning rule, it's plainly touching someone else. Well-written laws are rather clear, but sometimes what appears clear to you may not be quite as obvious to other people. To further complicate matters, lawyers who are hired by the side that doesn't like the outcome that the plain meaning rule gives them will use their best effort to obfuscate the plain meaning to convince those judges that the plain meaning isn't so plain after all. Another tool courts use is legislative intent. Judges will look to the person who made the law in question and try to divine what they were trying to accomplish when they passed the law. The court has several ways to figure this out. They may review the debates over the law in the legislative chambers if they were recorded. The court may look to what was happening in the news at the point in time. Looking at our last example of battery. If the court were unable to use the plain meaning to establish what qualifies as a touch, they might say that a finger poke is not a touch if they believe the law was put in place to punish unwanted touches that hurt people. The last tool the court has is public policy. If the language is unclear and the court cannot divine legislative intent, they will consider what the best use of the law is. In previous cases, the Supreme Court has held that if a law were passed, it must have been passed for a reason. Therefore, not being able to find a clear interpretation is insufficient reason to invalidate the law. When considering public policy, the judge or justices will apply the law in the manner they feel best helps society. Interpreting the law this way is frequently considered controversial. Often, when people complain of activist judges, they're talking about someone ignoring what they personally believe to be plain meaning so they can apply a politically motivated public policy. When presented with a legal question, the court should first and foremost consider if there is case law clarifying the language. Then they should move through these tools in order. But judges are people like anyone else. Ideally, we, and also judges, weigh evidence carefully and then come to a conclusion. But often what people do is come to a conclusion first and then find evidence to reinforce their already formed conclusion. Judges are no different. What it takes to get your case heard in civil court. We've discussed the makeup of court. Now we'll go over what it takes to get a case heard by the court. You're going to begin in a trial court with original jurisdiction. There are some things you need to ensure to have your case heard by the court. 1. The plaintiff must have standing. 2. The case must not be moot. 3. The court must have personal jurisdiction over the parties. 4. The court must have subject matter jurisdiction over the parties. 5. The court must be in the proper venue. Standing. Standing simply means that the plaintiff is directly affected by the controversy he's suing over. There are some exceptions to this where a person is given standing by law automatically, but in most cases, the plaintiff and defendant must be impacted personally by what is being sued over. Imagine that you're driving home and you witness a car accident. It's clear to you that the person who caused the accident was speeding and driving drunk. You decide to sue. The case would be dismissed for lack of standing. In this case, the only person who was hit by the negligent driver could sue. You simply witnessed the accident. You were not affected by it. You do not have standing. Mootness. When the jury, or the judge, if it's a bench trial, issues a final judgment, that judgment must have a real impact on the parties. You cannot sue as an academic exercise or just to make a point. Let's say that your state passes a law criminalizing the possession of energy drinks with 200 milligrams or more of caffeine. You, the owner of a convenience store, can no longer sell some of your most popular products. You sue to challenge the law. As your case progresses, the law is repealed after several legislatures are caught shotgunning Monster Energy on a cell phone video. Your case will then be dismissed for mootness. Even if you win, it would no longer matter because the law no longer exists. Personal jurisdiction. Any court that renders a decision must have the authority to enforce that judgment. If you live in Washington State and a person sues you in Maine, that judge has no more authority over you than a random person on the street. It's just like if a member of the British royal family were to tell you what to do. Good luck with that. We solved that one in 1776. However, if the court does have personal jurisdiction, sometimes called in personam jurisdiction, then their orders are binding and can be enforced. The court has a handful of ways they can exert personal jurisdiction: residency, consent, and through long-arm statutes. Courts have in personam jurisdiction of all the residents of their state. If you live in San Diego in Southern California, courts in Weed, a city in Northern California, can exert personal jurisdiction over you. The second is consent. A court can exert personal jurisdiction if you grant them that authority. This is largely why we don't concern ourselves much with whether the court has personal jurisdiction over the plaintiff. The plaintiff is choosing the court they're filing the case into, so they're obviously consenting to that court, and in turn that state having personal jurisdiction over them. If they didn't consent, then they would have filed somewhere else. By responding to the plaintiff's case, the defendant is acknowledging and granting personal jurisdiction to that state. It is possible to make a special appearance where you show up for a court case, but you're doing so only to challenge that court's jurisdiction. This way you can challenge that singular aspect without consenting to the court's jurisdiction overall. Lastly, and most difficult to address, is the minimum contacts test. Every state has passed what are called long-arm statutes that grant their courts jurisdiction over out-of-state defendants. These long-arm statutes were upheld in a case known as International Shoe versus Washington. In that case, the court created a rule granting in personam jurisdiction to courts within a state if certain minimum contacts are met that line up with that state's long-arm statute. Minimum contacts are classified as being either casual or systematic and continuous. A casual contact is one where the out-of-state defendant is being sued for something they did within that state. An example of this would be a car accident. If you, as a resident of Washington, were to be on vacation in Florida and got into an accident with a Florida resident, that person could sue you in Florida court, but only for the car accident. The state would have sufficient minimum contacts to exert personal jurisdiction over you. Systematic and continuous contacts are those where the defendant is regularly within that state. How regular is sufficient? That's a question to be resolved by the courts using relevant case law. I am a resident of the state of Idaho. However, approximately 3 times a week I come to Washington to teach. I receive a paycheck from the state of Washington. My contact with Washington is systematic and continuous, and a plaintiff could sue me in Washington state for any reason at all, and the courts would have in personam jurisdiction. Systematic and continuous contacts become a little more complex when it comes to businesses, and doubly so when it comes to the internet. It can be argued that because a website is accessible to every state in the country, that anyone with a web presence has systematic and continuous contacts everywhere. In fact, this very argument was made in a case against the company that makes Zippo lighters. In that case, Zippo Manufacturing Company versus Zippo.com Inc., 952 Federal Supplement 1119, 1997. In that case, a district court in Pennsylvania created a sliding scale test that is frequently used by other courts. Note that this is a district court, so the court's opinion is not precedent, though it is persuasive enough that most courts abide by this test, with many turning it into case law within their jurisdictions. The Zippo test, as it's come to be known, allows courts to exert personal jurisdiction over out-of-state defendants if their website is highly commercial or interactive with the point of selling to people within that state. If that's the case, then it will be treated as though the contacts were systematic and continuous. If instead the website is more for entertainment or information with little commercial activity, then it will be treated as though it has only casual contact in the minimum contacts test of International Shoe. A person could exert personal jurisdiction outside of their home state, but only if the tortious activity were directed at the forum state. The job of the judge, as the arbiter of law, would be to decide where on this sliding scale a website should be situated. There's additional complexity that's added to personal jurisdiction when you're talking about real property. Real property are things like land and or things attached to land. Even if a court lacks personal jurisdiction, they must still be able to see a case related to real property due to in rem jurisdiction. In rem jurisdiction simply means that only courts within that state have the authority to address real property within that state. We do not want a judge in Nevada to tell Washington what they must do with their land. Only Washington courts can address real property issues within their own state. If that court lacks personal jurisdiction over the owner of that property, that person will still need to go to that state to defend claims against their property. Subject matter jurisdiction. Even if a court has personal jurisdiction, that alone does not mean that they can review a case. A court must also have jurisdiction or authority to address that specific subject matter. Subject matter jurisdiction is largely dependent on what type of court is reviewing the case. The two types of subject matter jurisdiction are courts of limited jurisdiction and courts of general jurisdiction. Courts of limited jurisdiction are limited to the types of subject matter they are allowed to review. Generally, the more populous an area, the more courts of limited jurisdiction will be present. Courts of limited jurisdiction include things like family law court, traffic court, drug court, courts of chancery, which are business law courts, bankruptcy court, or small claims courts. If you were to sue a person for breach of contract in a family law court, that court would lack the subject matter jurisdiction to address the case, and it would be dismissed at your expense. There are courts of limited jurisdiction in both the state and federal systems. Courts of general jurisdiction can review almost any sort of subject matter with some very narrow exceptions. Appellate courts in both the state and federal system are courts of general jurisdiction. Courts of general jurisdiction may review cases on contract disputes, family law, criminal law, wills and trusts, and so on, sometimes even on the same day. Federal trial courts, those district courts we discussed earlier, are also courts of general jurisdiction. However, most civil cases begin in state courts. For a case to be seen in district court, it must involve either a federal question or diversity of citizenship. It's worth noting that even if you can get your case into federal court, that doesn't always mean you want to. Federal question cases are those that involve federal law. You might be suing someone and alleging a violation of the Constitution. You might sue under a federal statute, such as when people sue the police for abuses under statutes like 42 U.S.C. 1983. Perhaps you're suing your employer under a federal whistleblower statute or administrative agency regulation for an OSHA violation. These all involve federal questions that can be reviewed in district court regardless of the amount of money you're suing over. Diversity of citizenship grants subject matter jurisdiction to district courts in the event the plaintiff and defendant are citizens of different states and the amount in controversy is greater than $75,000. If you sue for exactly $75,000 in federal district court, your case will be thrown out for lack of subject matter jurisdiction, so you'd better find an extra penny of damage. One of the unique parts of district court is that court is not bound by the laws of the state in which it sits. It may choose the laws of whichever state it chooses after conducting a careful conflict of laws analysis. State court, on the other hand, is bound by the laws of the state in which it resides. This might be one of several factors a plaintiff might consider when deciding whether they want to file in state or federal court. Venue. The last thing a plaintiff needs to have when choosing a court to file their case in is a court with proper venue for the case. For a state case, that means you must file in the proper county. For a federal case, it means you must file in the proper district. Proper venue is the place that is the most fair for the parties. Venue, it's a lot like personal jurisdiction, but it's not exactly the same thing. Jurisdiction is about the court's authority. Venue is about fairness for the parties. Consider the cities we mentioned when talking about personal jurisdiction. If there's a car accident in San Diego in Southern California, then a court in Weed, Northern California, would have personal jurisdiction if both parties were residents of California. However, venue would be improper in Weed because it's so very far away from the scene of the accident. This doesn't always mean that you must file in San Diego County, exactly where it happened, but it does mean that the county you file in must be fair to all the parties and the witnesses involved. How to begin a lawsuit. You have decided which court you intend to file your lawsuit in. You've decided on a court with original jurisdiction. You found a court that will have personal jurisdiction. You found a court that has subject matter jurisdiction. You found a court that you believe has proper venue. Now you're ready to begin the pretrial process. This begins with the filing of the appropriate pleadings and ends in a court judgment which may or may not involve a trial. Let us begin with the filing of the appropriate pleadings. Pleadings. Pleadings are the initial documents that lay out all the accusations and defenses of the case. There are only 4 major pleadings. Only 2 of these are required. 2 more of these are optional. The required pleadings are the complaint and the answer. The optional pleadings are the counterclaim, sometimes called the cross-complaint, and the reply. Complaint. The complaint is the first pleading filed with the court. The plaintiff files this pleading in the court of their choosing. In the complaint, the plaintiff informs the court why that court has personal jurisdiction, subject matter jurisdiction, and why venue is proper. Then the plaintiff makes factual allegations about what the defendant has done to cause them harm, justifying the lawsuit. The complaint ends with the prayer for relief. The point of a lawsuit isn't simply to go and complain to people. You want the court to actively do something about it. The prayer for relief is you telling the court exactly what that something is. The plaintiff takes the complaint and files it with the court clerk, along with another document called the summons. The court clerk will give the case a number, officially opening the case. The summons is a document that tells the defendant that they've been sued and informs them of the legal obligations they now have, as well as what they must do next. What's most important in the summons is the notice that they must respond to the complaint within a certain amount of days. In most places, it's between 20 and 30 days. The plaintiff must take this complaint and summons and have them served on the defendant. Every state has different rules on how to accomplish this in the rules of procedure, but most states require that a person be over 18 and not a party to the case. Most of the time, plaintiffs hire a person called a process server to deliver the complaint. Some counties will even have the sheriff do it. It's important to serve paperwork on the defendant because he cannot defend himself from a lawsuit if he's unaware of it. After they've been served, the defendant must respond to the plaintiff's complaint within the time specified on the summons. If the defendant does not respond to the plaintiff by filing an answer, the plaintiff can request a default judgment with the court. In a default judgment, the court will grant the prayer for relief in the plaintiff's complaint within the bounds of justice. The presumption is that if the defendant isn't defending himself from the allegations in the complaint, then that must mean that he either agrees with them or doesn't care enough to disagree with it. The answer. The answer is the second required pleading in the case. This is filed by the defendant. The plaintiff is complaining in the complaint, and the defendant is answering the complaints in his answer. The answer is a much simpler document than the complaint. In the answer, the defendant is simply going to admit or deny each of the accusations made by the plaintiff. The document can be as simple as saying, I admit to paragraphs 1, 2, and 7, and I deny everything else. The defendant may also add some affirmative defenses to their answer. With an affirmative defense, the defendant is explaining why they did what they did and why the plaintiff must lose, even if those allegations against them are true. Perhaps there was a breach of contract, but it was past the statute of limitations. So even though the breach of contract did happen, the plaintiff waited too long to bring the matter to court. Counterclaim. It is common, but not always the case, that the defendant not only believes that he was not at fault for the damages he's accused of, but the fault belongs instead to the plaintiff, so he's suing the plaintiff right back. Perhaps the plaintiff is suing for damages in a car accident, alleging that the accident happened because the defendant was speeding. The defendant might allege that not only was he not speeding, or maybe even he was, but the real fault of the accident was instead due to the plaintiff texting while driving, not him speeding. The defendant must still file their answer as required by law. Additionally, they will file a counterclaim, sometimes called a cross-complaint. The counterclaim will look nearly identical to a complaint, except in how the pleading is titled and the fact that it's being filed by the defendant. Remember, a counterclaim is not required by the defendant, but an answer is. Reply. If the defendant has filed a counterclaim, then the plaintiff must file a reply. The reply is the plaintiff replying to the allegations made by the defendant in the counterclaim. A reply is required only if the defendant has filed the counterclaim. It will look nearly identical to the answer, except in how the pleading is titled and the fact that it's being filed by the plaintiff. So the pleadings would go like this. The plaintiff files the complaint. The defendant responds with an answer. The defendant files a counterclaim. And the plaintiff responds with a reply. The pretrial process. Once the pleadings have been filed, the court will begin to take notice, and the pretrial process will begin in earnest as the parties prepare themselves for trial. This process includes discovery, pretrial conferences, pretrial judgments, settlements, and motions. Discovery. Discovery is a process where each side discovers or uncovers evidence relevant to the case. There are many ways the parties go about doing this. The process of discovery is governed by a state's or the federal rules of civil procedure. The most common form of discovery is a written discovery packet. As part of this written packet, there are interrogatories, requests for production, and requests for admission. Interrogatories are questions directed to the other party. If you're suing over a car accident where you've accused the other party of driving negligently, you might ask how fast they were driving. You might ask when the last time they changed the brakes was. You might ask about the last time they drank alcohol. Request for production. Requests for production are you asking the other person to produce physical evidence. The person you're suing for damaging your car might have a request for you to produce a copy of the bill from the auto shop to verify the damage to your car. They might ask you to produce pictures of the scene of the accident or copies of police reports. They might ask you to produce dash cam footage if you have it. They're requesting actual physical evidence or copies of it. Requests for admission are simply accusations. For this scenario, you might say, please admit that you were changing the radio station before the accident, or please admit that you were not wearing your seatbelt if someone is suing for medical damages from the accident. The person receiving the request for admission need only reply, admit, or deny, and needn't to explain themselves further. So it's wise when using requests for admission to ask the same question different ways to ensure that the other person cannot simply deny something on a technicality. The discovery packet will be given to the other party, or their lawyer if they have one, and must be responded to within the time set out in the rules of procedure. A failure to do so in a timely manner may have dire consequences for the case. The discovery process may also include collecting depositions. In a deposition, a witness is summoned, placed under oath, and questioned as though they were on the witness stand in a trial. These depositions are frequently recorded, or their testimony is transcribed. The purpose of these depositions may be to uncover additional evidence or get testimony while memories are still fresh. Depositions serve the additional value of being used to ensure witness testimony is truthful by showing it to a witness if they testify differently during a trial. Another great value in depositions is to find out answers to your questions before trial. If the witness is testifying in a way you don't like, you'll know not to ask that question at trial in front of the court. As part of the discovery process, you may also seek out experts to conduct tests and examinations. In some cases, you'll need the court to compel the other side to cooperate by filing a motion. We'll discuss them shortly. Examples of this might be drug testing if there are allegations of drug abuse related to the case, such as a child custody dispute. You might seek out experts to provide the valuation to a home or business if the parties cannot agree on its worth. Motions and pretrial judgments. Throughout the pretrial process, occasionally the parties might file motions with the court. Motions are simply requests made by the court that you're asking the judge to rule on as a matter of law. You will file a motion, and the other side will have the opportunity to respond. Sometimes your motions will have different statutes, rules of evidence, or case law to support them. After the motion has been filed, the other side will have the chance to file a response, and the parties will sometimes be able to argue in front of the judge before she issues her ruling on the request. A motion to compel, for example, is a motion you use to get the other side to do something they are refusing to do, such as to return your discovery request, to submit to a drug test, or to stop spending shared assets. You might file a motion requesting that evidence not be shown to the finder of fact at trial. You might file a motion allowing a witness to testify over the phone or the internet rather than in person. These are just a few, but most any request you make of the court must be presented as a motion, allowing the other side to argue against it. Two major motions that can end a case before it even gets to trial are a motion for summary judgment and a motion for a judgment on the pleadings. Both motions are similar in that the judge will be presented with a legal argument that there's no actual disagreement about what the facts of the case are, or that such disagreement doesn't matter because a winner must be declared as a matter of law. Remember, the point of a jury or a judge in a bench trial is to be the finder of fact. We have trials for the purpose of the finder of fact to do their job. If there's no question of fact, then there's no requirement that we have a trial, and the judge, as the arbiter of law, can rule for a winner. The only real difference between the two motions is when they occur. A motion for a judgment on the pleadings comes after the pleadings have been filed. Recall, we only have 4 pleadings: the complaint, the answer, the counterclaim, and the reply. After the pleadings have been filed, if there's no question of fact, the judge may choose a winner as a matter of law based only on the information in the pleadings. No question of fact simply means that no one's denying that the allegations made in the pleadings are true, or that the judge decides that the facts where the parties disagree aren't even relevant. This would be like if everyone agrees that there was a breach of contract, but the statute of limitations has already passed. With a motion for summary judgment, once again, there's no question of fact, or the disagreement over the facts aren't relevant. But now, instead of just the pleadings, you've likely gone through the discovery process to aid in that determination and are attaching evidence to the motion for summary judgment. A motion for a judgment on the pleadings comes after the pleadings have been filed. A motion for summary judgment can come at any time prior to trial. Pretrial conferences. Throughout the pretrial process, there will also be pretrial conferences. Pretrial conferences will happen at regular intervals and involve all the parties as well as the judge. The point of a pretrial conference is for the judge to address any lingering issues in the case, as well as ensure that the case is advancing smoothly. The judge will be checking in to make sure things like discovery are being completed and that the parties are not simply stalling. The judge will also make sure that no additional motions need to be filed. During pretrial conferences, the judge will schedule due dates for motions, for completion of discovery, disclosure of witness, and exhibit lists to be used at trial, and will set a date for the trial itself. The judge may also seek, during the pretrial conferences, to get partial agreements limiting the facts that need to be addressed at trial. For example, if you're dissolving a partnership, the parties might agree how much an outgoing partner is going to be paid from the business accounts, but they might disagree about the value of the property the outgoing partner is entitled to. If they can agree on part of the case, then it will limit the length and the issues addressed at trial. Trial. Once all the pleadings have been filed, discovery completed, the motions have been heard, and the final pretrial conference has occurred, you're ready for trial. Trial consists of voir dire, opening statements, the plaintiff's case in chief, the defendant's case in chief, closing statements, and finally deliberation and judgment. Voir dire. Voir dire is simply the selection of the jury. Prior to trial, there will be several more jurors in the courtroom than those in the jury box. The parties' attorneys, starting with the plaintiff's attorney, will have the opportunity to ask questions of the jurors. The goal is to dismiss those jurors who cannot judge the case impartially. Perhaps they have had negative experiences and developed biases against one of the parties or a group associated with them. If the lawsuit is about a breach of contract for selling a bad car, and one of your jurors was previously sold a lemon, it might cause a bias against the defendant. Maybe a juror has a bias for or against a demographic or occupation relating to one of the parties. If a juror demonstrates through the attorney's questions that they cannot judge the case impartially, or there's some other complication, that attorney will request to the judge that the juror be removed for cause. If the juror is removed, she is replaced by one of the extra jurors in the courtroom. When both attorneys have had the chance to complete their questions to the jury, they will additionally have a set number of peremptory challenges, where they're allowed to have jurors excused due to any undisclosed reason the attorney might have, so long as those reasons are not discriminatory. Opening statements. After the voir dire process is completed, the attorneys will begin their opening statements. The plaintiff's attorney will begin by providing the jury, or judge if it's a bench trial, their theory of the case. They're telling a story about what they believe happened and what they expect the jury to conclude after hearing all of the evidence. Opening statements are not evidence, but they prime the jury and help provide guidance regarding what they expect to hear from the witnesses and how the plaintiff expects it to fit into their theory of the case. When the plaintiff's attorney has completed his opening statement, the defendant's attorney will begin hers, giving her theory of the case and how the testimony from the witnesses should bring the jury to a different conclusion. The case in chief. Now the actual case begins. The plaintiff will go first by calling their first witness. The case in chief is the only actual evidence a jury should be considering when drawing their conclusions. No matter how eloquent or convincing an attorney might be, it is the evidence provided by the witnesses alone that should guide a jury's judgment. The witness will be sworn in by the court clerk. The plaintiff's attorney will begin by asking questions of their witness in what is called their direct examination. What is unique about direct examination is that the attorney must ask open-ended questions. They cannot ask leading questions. Leading questions, which are commonly yes or no style questions, direct the witness to what testimony that the lawyer wants to hear. An example of a proper question would be, where were you last Friday night at 6 p.m.? Whereas a leading question might be, last Friday night at 6 p.m. you were at the barbershop, weren't you? When the plaintiff's attorney is done with their direct examination, the defendant's attorney will ask questions of the same witness. This is called cross-examination. These questions are designed to clarify or provide context to the answers given during a direct examination. During cross-examination, the attorney is allowed, and often does, ask leading questions. This is because the witness is not always going to be friendly and forthcoming with information to the attorney who did not call them to the stand to help their case. After cross-examination is complete, the plaintiff's attorney can again ask questions during redirect examination to clarify and provide context to the testimony given during the examination. Then the defendant's attorney will ask questions during re-cross-examination. The parties will continue to take turns in this way until neither side has questions for the witnesses. The judge will then allow the witness to step down. This process will continue as the plaintiff continues to call each of their witnesses. When the plaintiff is out of witnesses, they will inform the judge that they rest their case. Now the defendant will have a chance to begin their case in chief, calling their witnesses. When they have finished with their witnesses, the defendant's attorney will inform the court that they rest their case. Remember, the person who is called the witness engages in direct examination. It is the other side only that can engage in cross-examination. Rules of evidence. Frequently in court, you will hear attorneys make objections during testimony. If you watch courtroom dramas or cases on television, you might hear an attorney object to testimony being given by the witness. Every state and the federal system have their own rules of evidence. These rules limit the type of evidence that is legally permissible for the judge and jury to hear or consider when making their decisions. This is supposed to ensure that a case is decided on its merits rather than any emotional or prejudicial reasons. When an attorney makes an objection, they must explain to the court why the evidence should not be considered or heard by the jury. A common example of this would be hearsay, which is Rule 801 of the Federal Rules of Evidence. If the court agrees that the testimony violates the rule of evidence and should not be admitted, then the judge will say that the objection is sustained and cannot be asked or answered. If it has already been answered, the jury will be instructed to disregard that answer. If the judge wishes to allow the testimony, she will say that the objection is overruled and the witness may continue to answer the question. Closing statements. When both sides have completed their case in chief, the attorneys will make their closing statements, starting with the plaintiff's attorney. When the plaintiff has completed his closing statement, the defendant will begin hers. Lastly, the plaintiff will be given another chance to rebut what was stated by the defendant during her closing statement. The closing statements will closely mirror the opening statements, and the parties will repeat their theory of the case. Whereas in the opening statement, the attorneys informed you about what they expect the jury will hear from the witnesses and how it fits into their theory of the case, now they'll be talking about what the witnesses actually said and what conclusions should be drawn from that evidence. Most of the witness testimony should not come as a surprise to the attorneys, especially if they did a good job conducting discovery. They already know the answers to the questions they're asking, especially during direct examination. However, there are often surprises and things that were unexpected during trial, and this is the attorney's chance to work those statements into their theory of the case. Deliberation and judgment. After the closing statements, the judge will provide instructions to the jury. Instead of just asking them to pick a winner, the judge will outline all the relevant law and what findings of fact they must come to for them to make certain conclusions. For example, when we cover negligence, we'll address the 5 elements necessary for a person to be found liable for negligent behavior. The judge will not ask if the defendant was negligent in general, but rather whether all 5 elements of negligence were met. The judge will inform the jury that if not all 5 elements were met, then they must find that there was no negligence. The judge will also explain the burdens of proof to the jury and who must carry that burden. Most of us are familiar with the burden of proof in criminal cases. Guilt must be established beyond a reasonable doubt. There are some exceptions, but in most civil cases, that burden is lessened to a preponderance of the evidence. This means that it is more likely than not, even if only 51% likely that the bad act happened, the jury must then find the defendant responsible or liable for the damages suffered. The judge will also explain that the burden is on the plaintiff to prove their case. In a criminal case, we've all heard that a person is considered innocent until proven guilty. Similarly, in most circumstances, a defendant is by default considered not liable or not responsible for the plaintiff's damages, unless the plaintiff proves their case by the appropriate burden of proof. Page 57, I've given you a chart of burdens of proof. The jury, having been properly instructed in the law, will deliberate in private and, when ready, return with a verdict. In federal court, a jury must be unanimous in their decision. In some state courts, such as Washington, a simple majority may decide who wins in a civil suit. In all criminal cases throughout the country, a jury's verdict must be unanimous. In the event the jury cannot reach a unanimous verdict where it is required, the result is a hung jury. The result of a hung jury is the same as a win for the defendant, with some additional caveats we will not cover here. It is uncommon, but possible, that despite sitting throughout the trial, the judge may issue final rulings that go against what the jury has decided. In the event the testimony provided by the witnesses demonstrate that there is no question of fact, the judge may make a ruling as a matter of law, just like with a summary judgment. More commonly in these situations, though, the evidence is so lopsided that the judge finds that no reasonable jury could find for anyone other than who the judge believes should win. In this case, there are a few things that may happen. The judge may order a directed verdict or a judgment notwithstanding the verdict. In a directed verdict, the judge will inform the jury that no reasonable jury could find for anyone different than one party, and shall order the jury return a verdict for that person. It's important to note, however, that a judge cannot punish you if you fail to follow this instruction. You should take a moment and review the concept of jury nullification. There are many great videos about it on YouTube. However, never make it known during voir dire that you're aware of this concept, or you'll be stricken from the jury pool. Sometimes, instead of giving a directed verdict, the judge will allow the jury to return with a verdict like normal. But again, if no reasonable jury could have sided with that party because of the incredible weight of the evidence, the judge might vacate or disregard the jury's decision and issue her own verdict. This is rather uncommon, though. Juries are held sacred in our justice system, and we generally honor their judgment. For a judge to order a directed verdict or a judgment notwithstanding the verdict, it's not enough that she disagrees with the verdict, but rather that no reasonable jury could come to the conclusion they did. Most of the time, this means there are pretty clear signs of favoritism or discrimination. So, the proper flow of a standard civil trial. The plaintiff begins voir dire, then the defendant does voir dire. The plaintiff does opening statements, the defendant does opening statements. The plaintiff does their case in chief, the defendant does their case in chief. The plaintiff gives their closing statements, the defendant gives their closing statements. The plaintiff gives a rebuttal closing statement. There are jury deliberations. The court issues its judgment, and there are appeals. Post-trial issues. Sometimes winning is only half the battle. But just because you win doesn't always mean that you're going to get what you want. Just because a judge orders something doesn't mean the person that was ordered to do it will actually do it. The court needs a way to enforce their judgment. The court has a few ways they can do that. Some of these are writs of garnishment, writs of execution, or holding someone in contempt of court. With the writ of garnishment, the winning party must file a request with the court. If the court grants that request, the losing party's employer, or another third party in possession of the loser's property, will be served paperwork demanding that all or some of that property be given over to the winner. If instead the court orders a writ of execution, the court will have law enforcement seize the loser's property, auction it, and deliver the proceeds to the winner. Sometimes money cannot solve the problem. Maybe the court judgment involves a custody order for children. Maybe the court ordered that an easement is granted, giving the winner access to the loser's land. If the loser fails to follow the orders of the court will hold that person in contempt of court. A person in contempt of court can be given criminal penalties up to and including jail time for failing to follow the court's orders. The loser, having had their day in court, may possibly, according to the court's rules, request a rehearing. But in most cases, the loser's main option is to appeal to the next higher court. Appeals require the loser to make the request in an appropriate time after the judgment established by the court's rules of appellate procedure. They will then file appropriate briefs alleging a mistake of law by the court, such as improper jury instructions or ruling on the admission of evidence. It's possible to appeal based on the lack of evidence to support the verdict, but the appellate courts overwhelmingly trust the judgment of the jury, especially given the fact that the jury was present to hear the witness testimony, whereas the appellate court justices will hear no new evidence or see any witnesses. After the appropriate briefs are filed, there'll be a period of oral argument and the appeals court will render their opinion. Alternative dispute resolution. Not all legal disputes are required to be dealt with by going through the entire trial procedure. Trials are expensive, time-consuming, and often result in a great deal of anger and animosity between the parties. It also takes the affected parties out of the equation, disallowing them any control over the outcome of the case. Even when the law and evidence seem obvious, we sometimes still get unexpected outcomes. To avoid this, there are several other options available for the parties to resolve their issues outside or alongside the court system. This includes, but is not limited to, settlements, mediation, arbitration, or private judging. Settlements. Negotiated settlements happen all the time. In fact, most cases are resolved outside of the court system. The negotiation process can happen before a trial and continue all the way through trial until there's a final judgment. Often, before a case is even filed, the prospective plaintiff's attorney will send out a demand letter informing the defendant of what they're about to be sued for and granting them a chance to avoid the lawsuit by stopping their bad act, making agreements, or paying damages. Negotiations may occur by phone calls, meetings in person, faxes, or emails. The parties' attorneys will be communicating settlement offers and negotiations all throughout the pretrial process. There are many great reasons to settle outside of court. By settling outside of court, the parties have some control over the outcome. Sometimes parties can negotiate a payment of damages without the defendant having to publicly admit responsibility, which is always attractive to businesses who actually have done something bad, and avoid the bad press or reputational damage of airing dirty laundry in a public jury trial when it can be avoided. Because the court wants to encourage settlements and compromise, any negotiations or offers to settle are excluded at trial under the rules of evidence, so making an offer to settle cannot be used against you as evidence of being liable for the bad act at trial. If the parties agree to settle, they will provide the court a copy of the judgment they wish for the court to sign. Unless the court finds some sort of legal defect in the request, the court will sign that order and it will become the binding legal judgment of the court, just as if it were issued by the court itself at trial. Mediation. Mediation is a very popular tool to resolving disputes. With mediation, the parties meet with an impartial third party who will help identify issues and assist the parties in coming to a solution that everyone can agree on. Mediation can occur before anyone even takes a matter to court. Mediation can also be agreed to by the parties before trial or ordered by the judge during a pretrial conference. Because the mediator is impartial and assists the parties to come up with an agreement themselves, mediation is ideal for situations where the parties need to continue a positive relationship after the dispute is settled, such as contract disputes where the parties desire to continue business afterward, or parents who will need to co-parent a child for years to come. Arbitration. Another common form of dispute resolution is arbitration. Many consumer contracts include requirements to seek arbitration prior to initiating a lawsuit. Arbitration differs from mediation in that the third party will weigh the evidence and determine how to resolve the dispute. The arbitrator picks a winner, a mediator does not. Arbitration can either be binding or non-binding. With binding arbitration, the arbitrator's decision is final, and you cannot take your dispute to court afterwards except in very narrow circumstances. With non-binding arbitration, if the parties are dissatisfied with the decision, they can still take the matter to court. Private judging. Private judging is much like arbitration. The parties find a person to act as a judge to hear their case. Most of the time, the private judge is a retired judge or someone else who's an expert in the field. Private judging is also popular in situations where different laws are to be used, such as when the parties want religious rules to be considered when rendering a final judgment. Private judging can include anything from television judges, like Judge Judy, all the way through to religious judges.